Hello, everyone. Good afternoon and or good morning. We thank you for joining today. Today we have the pleasure of meeting with Anna McCormack of Warren Allen Allen LLP, sorry, and she's going to be discussing Portland's fair law with us today. We would like to remind everyone that the information in the materials presented by Anna and Warren Allen LLP are intended to be educational only and are not specific legal advice. You should consult your own attorney for advice regarding the application of the law to your individual circumstances. The law can change very rapidly, so please do not assume that any law discussed herein applies in perpetuity or that it remains as described. We have a few housekeeping notes for you this morning. We ask that you make sure that your phones, your computers, your mics are muted so that we can proceed with our presentation and complete it in the allotted time. We do ask that you hold your questions until the end of Anna's presentation. We have allotted time at the end of the presentation to field your questions. And about those questions, we will only be able to answer general questions. If you have a question about a specific situation, I ask that you contact Anna at Warren Allen LLP or your local counsel for official legal advice. Today, we also will be discussing some of the recent NAA forms. Those forms are currently live in Blue Moon, and samples can be seen on bluemoonforms.com. At this time, I'd like to welcome Anna to the stage, if you will. And Anna, take it away.
All right, good morning. My name is Anna McCormack. I'm an attorney here at Warren Allen. We represent landlords and property management companies throughout Washington and Oregon and have done so for several decades. I have a feeling some of you may know me or other Warren Allen attorneys, most likely via emails we've exchanged over the years. But today I will be discussing Portland's Fair Ordinance, which takes effect Sunday, March 1st, so just a few days from now. It applies to all properties located geographically within Portland city limits and nobody else. So presumably if you're here, that's because your property is within Portland city limits. Please note that the Fair Ordinance that we're discussing applies in addition to state law requirements. It doesn't exempt you from legal requirements that already exist under state law. It just adds an additional layer of regulation. Now, some of you may be aware that an industry group and a couple of landlords have filed suit against the city in federal court regarding the enforceability of the Fair Ordinance. Oral argument on the temporary restraining order is this afternoon. We'll see what happens. Unless and until a TRO is granted, we must be prepared for this to take effect on March 1st. And keep in mind that even if it is granted, that could be a very temporary delay. So in other words, we'll keep our fingers crossed, but we do need to continue preparation for Sunday, which is when all of what we're talking about today takes effect. At the outset, I'm going to comment that the Fair Ordinance and associated administrative regulations are quite complex and sadly pretty poorly written in that there are many ambiguities and even some internal contradictions. So today's webinar is a broad overview of the major points regarding FAIR, but we're not going to do an absolute deep dive because that would probably take about 8 hours. Because of the ambiguity, there are areas that attorneys are unable to provide clear, absolute, and unequivocal answers just because of the very nature of the language at issue. So we won't know for sure how certain provisions are going to be interpreted until they're litigated. Perhaps in the pending lawsuit I mentioned, and maybe in additional lawsuits over time. So I'm going to draw your attention as we move through this to some of the ambiguities, and note that legal opinions about some of these gray areas may change over time based on what we're seeing tenants' attorneys argue and what we're seeing judges decide. And so I'd like to reemphasize what Aisha said, which is that this should be a broad overview and give you a good idea of the main points. But when it comes to you making crucial decisions about your operations, you need to get tailored legal advice from time to time from your own attorney. Okay, so when I'm referring to the ordinance, I'm referring to a law passed by the Portland City Council in June 2019. And there are also permanent administrative rules from the Portland Housing Bureau, which weren't finalized until January 31st of this year. So basically less than a month, less than 30 days from the effective date. As you know, this gave the industry very little time to get forms, implement procedures. NAA worked really hard to get you the forms that Aisha referenced are available on Blue Moon. I'll be referencing those forms. We're not going to go through them point by point in detail, but you will know which forms to use and what you're using them for. In other words, when to use them. Okay, so after that long preamble, let's dive right in. The ordinance begins with application and screening. I have shared my materials, and Aisha, just let me know if for some reason they're not showing up. I'm going to assume.
Thank you.
Great. I'm going to assume that they are. So we'll just move through these. So on the introductory part, as I said, this was all passed in June 2019. The main goals that were articulated were a first-come, first-served system for processing applications, prioritizing accessible units, creating a rent-to-income ratio cap, and then limiting the use of certain aspects of screening criteria. So those were the goals. Now, I'm really not going to spend much time on the exemptions. If they're very narrow, they're going to apply to very few people. And my advice there is that if you look at these exemptions later when the materials become available to you for reproduction, if you think your property might be exempt, get some legal advice to confirm that before you assume that this does not apply to you. It's going to apply to most people. So I'm not going to spend a lot of time on that. All right, so the first provision is something called a notice of dwelling unit availability versus a wait list. Those are two fundamentally different concepts. You either do one or the other. If you are currently using a wait list system for filling vacancies, you would know it. And that's a pure wait list system, meaning that you're not advertising any availability to the public for new units. So the vast majority of landlords, I believe, are filling units, filling vacancies through advertisement. And so this is what the 72-hour notice of dwelling unit availability is designed for. And keep in mind that although it is called a notice, this isn't some specific notice form or specific form that the law requires or that Blue Moon has created. And that's simply because, again, although it's called a notice, the law simply just requires that your advertisement for a dwelling unit have certain content, certain information. And that is indicated right here. Any advertisement needs to indicate when you're going to begin to process applications, and that is called the open application period. That's going to be a date and time, and a description of your screening criteria, essentially, if you're going to charge a screening fee, and whether an available unit is an accessible dwelling unit. That has a very specific definition. And so if you're unsure whether the unit is an accessible dwelling unit, you're going to need to get some professional help to determine whether that is true, whether that applies. And you must publish this information at least 72 hours prior to that open application period, meaning the date and time at which you will begin processing applications. So in other words, you now have this kind of 3-day waiting period. You can't immediately advertise availability and just start taking applications 10 minutes later. Or in other words, you can't process them right away. There is this 72-hour window in between when you first advertise a unit as being available, a unit or units, and the open application period, which is the date and time in which you start processing applications in order of receipt, as we will discuss later. Now, notice in this subsection here, you can simply, in your ad, provide an address, website address, link, or some other method of communicating those, the contents, the required contents. So in other words, nobody in your Craigslist ad, I won't imagine that you're going to publish your entire criteria, because that would be incredibly lengthy and boring and hard to read. That means that you do have to have some sort of a link or address or something like that that will lead the tenant to where to get this information about when the open application period is, your criteria, and then whether it's an accessible dwelling unit. So again, the alternative to that is a wait list, and basically it's either or, so keep that in mind. If you're advertising at all, then that notice of dwelling unit availability does apply. If you're not advertising and you're solely using a wait list, then this applies. And again, I won't spend much time on that because I believe that most people are advertising. If you do use waitlist, there are Blue Moon forms. One is called the Landlord Waitlist Record, and there's one for an accessible unit and one for a non-accessible unit, because you do have to have 2 separate wait lists for accessible dwelling units and non-accessible dwelling units. So there are forms available if you do use a wait list as your means of fulfilling vacancies. The next thing that applies is there are some changes to application forms, screening fees. Now there are some certain requirements that must be included in your application form. The Blue Moon form for that is called the Portland Supplemental Application Form. That's available to you via Blue Moon. It can be used in conjunction with the existing application. So it's almost like an addendum to the application. And we've chosen to do an addendum because these things may change over time, and rather than reinvent the wheel, we can tinker with these supplemental or addenda forms. And ideally, you will have applicants complete the supplemental application form prior to the rest of the application, and we'll discuss why that is. It has something to do with the concept of financially responsible applicants. But in any event, there is a form, and that form meets these requirements because now the application has to provide the applicant with an opportunity to affirmatively indicate a mobility disability or any other disability status. It's just an opportunity. They can choose not to disclose that. If they do disclose it, there may be consequences in terms of how you process the application when your open application period begins. Next, it must also include a city-generated notice regarding a right to request a modification or accommodation. And that is, and I'll just flash to it, it is available via Blue Moon so that you know what it is, but I'm going to scroll down real quick so that you know what I'm talking about. So that's this. So your application is going to include this form right here. And this is a city-generated form. So it's exactly what they want you to send. Here's page 1. Notice down at the bottom in kind of the faint left hand where it says 1 of 4. Anytime you are seeing a city form, please look down and make sure that when you're using it, you're including all pages. For example, if you just include 3 of the 4 pages, technically you will not have complied with the law. So always double check and make sure that you are doing, so this is page 4, for example. You have to include that in your application packet. All right. Now, there is also a statement of applicant rights and responsibilities. That is another form. Again, I can show it when we get to the end here. It is, once again, available on Blue Moon. And it's just something that is now part of your application packet. Then you do have to, if you're charging a screening fee, you have to have your criteria and evaluation process. This isn't new, so I think you're going to be comfortable with that aspect of it. Finally, the application does have to now include an opportunity for an applicant to provide what's called supplemental evidence for the landlord's consideration to mitigate any potentially negative screening results. And again, Blue Moon, the supplemental application form has a space for them. It tells them that they can do that. And thus, as long as you're using this Portland supplemental application form in conjunction with the existing application form, you will be able to meet these requirements. All right, so screening fees. The bottom line here is that if you are relying solely on a screening company to perform your screening, you cannot charge anything extra beyond what the screening company is actually charging you. If you're using a screening company, but you're also conducting some sort of applicant screening on your own, then there is a 25% add-on limit to what you can charge on top of your actual hard cost from the screening company. And then if you're not using a screening company at all, then you can't charge anything that's 10% more than what a screening company would charge, which isn't a hard number. I don't know that there are a lot of people that don't use a screening company at all. So if you are one of them, you may want to get some tailored legal advice about what that number might look like. In other words, so you generally aren't able to sort of profit on screening fees. Moving forward, so the heart of this and a lot of these requirements is this first come, first served concept. It really is fairly self-explanatory except for a couple of quirks. So remember the notice of dwelling unit availability, in which you have to say what your open application period is, a date and time that you will start processing applications. And that's precisely so that you can comply with these rules and then process them in order of application as provided by the law. So the first thing, the Blue Moon form is called Landlord's Record of Receipt of Complete Application. It's a landlord's record of receipt of complete application. That's an internal form. That's not something that you're giving to a tenant or that you have to serve on an applicant, but it is very useful to use to implement these required procedures, because as you walk through it, it helps you do kind of the order of processing that is required by the law. So you do have to record the date and time that you actually receive it. And then there is a kind of peculiar provision of the ordinance that says that a premature application, which is an application that is submitted prior to that date and time that you say you will start processing applications, there's essentially an 8-hour penalty for any applicant who turns in their application early. And so you also, if you have received an application prior to that open application period start time, then in addition to recording the actual time of receipt, you must also then record what we're kind of calling the 8-hour penalty, which is 8 hours after the start of the open application period. So for a concrete example, if your notice of dwelling unit availability says that you will begin to process applications at 9:00 a.m. on March 2nd, 2020, and you receive an application the day before, then when you are using your landlord's record of receipt of complete application, you are recording the actual date and time that you received it on, say, Sunday, March 1st. But then you are also going to record this 8-hour later. So 8 hours after that 9 a.m. stop time would, of course, be 5 p.m. So you're going to write down and act as if you had received it at 5 p.m. on that open application period for purposes of processing first come, first served. There is yet an exception to that when it comes to mobility disabled applicants. We'll discuss that in a moment. So once it's very crucial that you record the actual receipt, and if it was a premature application, that you also record the sort of penalty time that you're going to end up using. It says that you can simultaneously process applications, but you have to conditionally accept or deny applicants in order of receipt. Hopefully you have actually been doing first come, first served as a general concept for many years for fair housing reasons. And this will just add sort of extra detail and layer for you. You'll see here that you can refuse to process an application of an applicant who has verifiable repeated rental agreement violations with that same landlord, if the most recent violation occurred within 365 days. You will also see that I've noted that this is such a narrow provision that I feel that it's almost useless, and it's very rarely going to be available, because as the permanent administrative rule defines this, it requires that you must have served 3 written notices on the tenant for those violations within the preceding 365 days, and that those violations cannot have been cured. And so you can see there that that's going to knock a whole lot out. I mean, if they kept a receipt, you might have given them 20 violation notices within the past year, but if they cured each and every one of them, this isn't going to apply. So I would not hang your hat on this. I think it's almost never going to be available to you. However, if it is, Blue Moon does have a form. It's called Portland Denial Due to Violations. All right, now you can refuse to process an application that is materially incomplete, that the person has not included sufficient identification, income information, or if they've intentionally withheld or misrepresented required information. A couple of caveats there is that the devil is always in the details. It's about whether it's materially incomplete. So it has to be a very major, significant missing item. For example, if you have a space where it requires a middle name and they didn't put their middle name, is that material? I don't think it is. But if they are a financially responsible applicant and they have provided no income information or no employment information, then it is materially incomplete. And but then you're essentially, it's not complete yet. And so you essentially can't process it. Notice it says if the applicant has intentionally withheld or misrepresented. Well, I'm not entirely sure how you can prove intent. So if these are areas where you think there may have been a misrepresentation, you're probably going to need to get tailored legal advice about that particular scenario. Now, there is a new requirement that if an applicant requests it, you must provide the applicant with a record of the date and time that the landlord received that completed application within 5 business days of the date they requested. And there's a form. The Blue Moon form is called the Portland Receipt of Complete Application. And that's something different. Remember, the landlord's record of receipt, that's for your internal use. The form that's called Portland Receipt of Complete Application, that is something that you would give to the applicant who has requested that you provide them with a record of the date and time that you received their application. And so you know that form has a space where you indicate not only when you actually received it, but that if it was in fact a premature application, the date and time that that it's 8 hours later that you are putatively receiving that. So it does contemplate premature applications. All right, so what's this exception I've been talking about in terms of accessible dwelling units? Again, accessible dwelling unit is very specifically defined. It's a unit qualifying as a, quote, type A unit pursuant to the Oregon Structural Building Code and another sort of building code. So it's a very technical, it's not a general idea of accessibility. I've had some people say, so does this mean if it's a ground floor apartment, I should say it's accessible because that's more accessible to people in wheelchairs? No, it's really a very technical, it's not sort of your guess on accessibility, it's whether it meets the standards for a type A unit. And I'm not an expert in that. That's kind of beyond the scope of landlord-tenant law because it gets into building code, ADA building code type requirements. So you may want to consult with ownership groups, builders, contractors, things like that if you are unsure, because you are going to want to know in your building whether you do have any accessible dwelling units in conformance with this definition. Because again, you're required to disclose that in the notice of dwelling unit availability, and it may have implications for how you process applications for mobility disabled applicants. So make sure you do get that information. I think many older buildings may have no units that qualify. Many newer buildings may have some units that qualify as an accessible dwelling unit. So if you don't have any accessible dwelling units, this isn't going to apply to you. If you do, there is priority to a mobility disabled applicant during the first 8 hours. So if you receive a completed application from an applicant during the first 8 hours of your open application period, then that is going to take precedence over an applicant who has not indicated a mobility disability. And again, remember back now on that supplemental application form that gives applicants the opportunity to disclose that. That's what you're going off of. If they haven't disclosed it and you don't have any other knowledge of a mobility disability, then you do not need to worry about that. But if they have checked a box indicating that they have a mobility disability or that someone in their household does, then that's when you prioritize them in accordance with this. But again, don't get confused. This doesn't mean for every unit. It simply means that if you have a unit that is an accessible dwelling unit as defined in the ordinance, and you receive an application from someone who has indicated a mobility disability, then if you receive that application during the first 8 hours of your open application period, that jumps to the top of the list. If you receive multiple applications from mobility disabled applicants during that time period, then you process those in order of actual receipt as between each other. And that's how that's going to go. There is some guidance in the PHB administrative regulations as to how you treat premature applications and so forth. It gets incredibly intricate, and so I'm not going to go into the nitty-gritty of that there, but basically, let's say you have it's not an accessible dwelling unit, then premature applications are all going to be kind of put at the bottom, remember, because there's that 8-hour penalty that you've recorded. And so anybody who applies early is being penalized, whereas if your open application period starts at 9 o'clock a.m. and you receive an application at 9 o'clock a.m., that's number one, and so on. And everybody who submits from 9 o'clock a.m. forward is going to have precedence over anybody that submitted early. Again, when we're talking about something that is not an accessible dwelling unit. If it's an accessible dwelling unit, again, that can get a little bit intricate, so you may want to seek a little bit of guidance if you think that that is going to apply to you. So if you look at the landlord's record of receipt, that form I've referenced, that really should help you process the order of applications when there is a mobility disabled applicant for an accessible dwelling unit. The form is an internal form. It helps you create your record of when things were received, but it also does have some step-by-step guidance that will help you process them in the right order. And just so you know, the definition of mobility disabled, it's defined as a disability that causes an ongoing limitation of independent, purposeful physical movement of the body or one or more extremities and requires a modifiable living space because of, but not limited to, the need for an assistive mobility device. I think it's good to know this definition. I've had some landlords talk about, well, can we require verification and all of those things? And I think for purposes of screening and applying the order of applications, I know there is no provision in the ordinance that references the ability to verify. So I think that doing so would risk a violation. This is something different. Don't get it confused with someone who's requesting a reasonable accommodation, which of course under the Fair Housing Act, you can require verification under most circumstances. If someone is requesting a modification to the unit, once again, verification is generally required. But this, just in terms of whether you can somehow require verification before even agreeing to process an application in accordance with this, it's just not referenced in there, and there isn't really any way to do that and comply with the ordinance. So it's one of the weird kind of ambiguities that's in there. It appears to be based on self-identification as mobility disabled, and that's about it. All right, the ordinance has some new identification requirements, and this applies to everyone. You simply cannot have an absolute requirement of a Social Security number. So you cannot require applicants to prove that they are lawfully present in the U.S. And in fact, you cannot inquire as to the immigration status of any applicant. So those areas are essentially illegal inquiries in Portland now. And you must accept certain types of verification now, and it's really simply geared toward verifying identity, nothing else. So again, because you can't require a social, you can't require anything about immigration status or lawful presence. None of that in Portland is considered to be legally relevant information any longer. Identity is still relevant, but you can require them to prove identity, but the City Council has decided that you must accept any of the following documents or a combination to verify the name, date of birth, and photo. So again, this is all just designed to what can they provide you that reasonably verifies that they are who they say they are, and that they are the person whose name and information is on the application and so forth. So one of the things is a Social Security card, but again, that's not an absolute requirement. Could be a permanent resident alien registration card, a visa, an immigrant visa, an individual taxpayer ID number, a non-immigrant visa. And here's number 6 is very important. Any government issued ID, regardless of the expiration date. So don't worry about whether it's an expired passport or an expired government ID of some sort. The expiration date doesn't matter. If it appears to be government ID and has a picture and so forth that appears to verify their identity, then that's good enough. Number 7, of course, is the catch-all. Any non-governmental ID or combination that would permit a reasonable verification of identity. So this is the famous Costco card provision, which everyone kind of says, what the heck does this mean? Does this mean they can give me their Costco card because it has a photo? Well, potentially, yes. Maybe they need some additional documents. Is a Costco card and nothing else sufficient? I don't know. But let's say in conjunction with all of the other items they've given you, for example, pay stubs, maybe a utility bill from their current residence, maybe you have information from their current landlord, they come in with a credit card, a library card, and a Costco card, and some utility bills, and it all matches up. As long as it's a reasonable verification of identity, this does say that that is good enough. So that may be quite different from what you're used to. The question I know that everyone is having is, if they don't have a social, how do we screen them for credit? Well, I mean, that's been, quite frankly, that's been a fair housing issue far preceding this ordinance. Fair housing advocates have, for many years, maintained that an absolute requirement of a Social Security number would be discriminatory as to national origin, because people from other countries may not have Social Security numbers. And so if you're interested in other means of proving creditworthiness, you can certainly look at perhaps the Fair Housing Council of Oregon's website. They have an entire sheet where they discuss other ways, but they basically suggest that if someone else has a good prior rental history, they have good employment and all of that, that's essentially good enough in terms of proving creditworthiness, and that the fact that they may not have a social and or a credit score shouldn't really be determinative. And depending on the type of criteria that you are using, it may be less relevant to you than it once was anyway. So these are some different requirements in terms of identification. Let's move forward to this financially responsible applicant, because this is one of the most significant changes enacted in terms of the application process. So if there are multiple people applying together, as commonly happens, the applicants get to choose a person or people who are going to be called financially responsible applicants. So there's those people, and then there's other applicants who have no responsibility, who have no financial responsibility, and for some peculiar reason, they have called these non-applicant tenants, even though, you know, at the application phase, nobody is a tenant yet. But who am I to question the verbiage of the ordinance? But so financially responsible applicant. The reason this matters is, so again, you don't have a say in this. And going back to the Portland application addendum, that the Blue Moon form that I referenced earlier, one of the other things it has on it, and one of the reasons I said that ideally you have applicants complete that before the main application, is because it asks them whether they want to be a financially responsible applicant or not, and sort of explains to them what that means and what the consequence of that is. And it's good for you because you need to know that information because it affects what you can and cannot screen them for. But again, they get to choose. You don't have a say over that. There does have to be at least one financially responsible applicant in order for all of them to get in. In other words, you can't have 3 people come in and they all say that they are non-applicant tenants. Well, then nobody gets in. But if one person says, okay, I'm the financially responsible applicant, and then the 2 other people say, no, I'm just a non-applicant tenant, then they can ride on the coattails of that financially responsible applicant as long as the financially responsible applicant meets not only the income criteria, but all other criteria. So you are limited in screening. So the only people that can now be screened for financial criteria are financially responsible applicants. So if people check the box, yes, I am a financially responsible applicant, then they can be screened for financial criteria. But if they check the box that says, no, I'm not going to be a financially responsible applicant, you cannot screen them for financial. It is no longer allowed. And you can still screen them for factors related to health, safety, property maintenance. That mainly means criminal background, perhaps rental history. So that's a very important distinction. Here's another one. There are now clear rent to income ratios. And I want to be really clear here that this applies to everyone. You can't opt out of this or have different rent to income criteria. You do have, and we'll discuss that later, you do have a choice about criteria, but not about this. This applies to everybody, regardless of whether you're going to elect to use Portland's low barrier criteria or whether you're going to use your own custom criteria. Either way, the criteria can't have anything that is any more stringent than this. So this applies to everyone. Financially responsible applicants, it only applies to financially responsible applicants because remember, this is an income criteria, a financial criterion, and therefore only applies to financially responsible applicants. And now there's a max, you know, people for many years have had 2.5 to 3 times the rent as income. Well, now that it's a max of 2.5 or it's 2 times the rent, depending on essentially what your rent amount is as compared to the number of bedrooms. There is a form here that I will go to in just a minute. We've elected, it is part of the supplemental application Blue Moon form so that you have it. It does not have to be provided to applicants, but it also doesn't hurt if you want to provide it to applicants. But it is primarily what you will use to determine whether you're, quote, a less expensive unit, in which case then you get to use the 2.5 times the rent income, or if you're a, quote, more expensive unit, which means that you're limited to a 2 times rent to income ratio. And so let's take a quick look at that. Okay, so here's the cover sheet that I've created. These materials will be available later to you, and this is just a reminder. So it's for your use in determining which ratio can be applied to financially responsible applicants. Note that they're going to update this. I mean, it apparently will be updated sometime this spring and presumably annually thereafter. And this is it. So you look at the number of bedrooms ranging from 0, which of course is a studio, up to 5. And if your rent amount is below it, then you're considered the less expensive unit, and you can go up to 2.5 times. If it is equal to or above that amount, then you're limited to the 2. So that, and again, this applies to everyone, and you cannot exceed it. So in other words, in Portland, can you ever have 3 times monthly rent as your income requirement? No, you cannot. You're either going to be at 2 or 2.5, depending on where your rent for that particular unit falls on that schedule. So when you're applying that rent to income ratio, you do need to include all income sources of the financially responsible applicants: wages, non-governmental rent assistance, monetary public benefits. It says that you may include verifiable friend or family assistance. There's really no guidance on what that means, so we don't know what, quote, verifiable means. We don't really know what that means yet, and it says you may include it, which isn't a shall. So my guess is that people are going to not necessarily interpret that as an absolute requirement. It's, in other words, maybe that's not verifiable income. If there is a voucher or some sort of subsidy, you have to apply that 2.0 or 2.5 rent to income ratio based on the amount of rent reduced by whatever that voucher is. And yes, I know that that may fluctuate over time, but it is what it is. You have to apply it based on whatever that voucher amount is at the time that you are processing the application. You must base it on the cumulative financial resources of all financially responsible applicants. And here's a very important point. The people that elect not to be financially responsible applicants, AKA the non-applicant tenants, well, their income isn't included. So you can't have it both ways. If an applicant wants their income to be included in meeting this rent to income ratio, then they have to designate themselves as a financially responsible applicant. If they don't, then their income doesn't get included. And that's part of what that supplemental application form explains to them. So in this one area, they can't have it both ways. I think it's designed to allow folks who, may have bad credit or other financial black marks to potentially still be able to rent as long as they are affiliated with someone who can be a financially responsible applicant. Maybe it's, one spouse with excellent credit and a high income, and then another spouse with no employment, bad credit, and so forth, and they don't want that person to be excluded, so the non-financially responsible person can sort of ride on the coattails of a financially responsible applicant. So Another thing to remember here is that if the financially responsible applicant or applicants do not qualify financially or otherwise, then that knocks out the non-financially responsible applicants or non-applicant tenants as well, because again, they can't independently meet the financial criteria because they're not financially responsible. You're not even screening them for that. But the converse, if you have someone who is a financially responsible applicant who applies with someone who is a non-applicant tenant, let's say the financially responsible applicant qualifies in all respects, but the non-applicant tenant, well, you have not screened them for financial because again, you can't, but let's say they do not qualify because they have a criminal conviction that disqualifies them, or maybe they have a general judgment of eviction that is, entered within the last year and doesn't fall within any exceptions, and that disqualifies them. Well, you cannot now reject the financially responsible applicant simply because their co-applicant who is not financially responsible did not qualify. If the financially responsible applicant qualifies, then you still have to offer them the unit even though their co-applicant didn't qualify. The financially responsible applicant may not elect to take that unit, or, as many landlords are concerned, they may elect to take it, sign that rental agreement only themselves, and then try to sneak in that person who didn't qualify. Will that happen? Of course it will. But keep in mind that you guys already see this happen all the time. The only difference being that, sometimes people don't even bother to apply when they know they won't qualify, and the person who qualifies sneaks them in. So that in and of itself isn't a radical departure. Unauthorized occupants pre-existed this. They will continue, and we will always have the potential ability to deal with that if you can prove the unauthorized occupancy, which is not easy to do. Okay. Very briefly, you can, if they do not meet the income requirement, and again, I'm just talking about that 2 to 2.5 rent to income requirement. If they don't meet that, but otherwise qualifies, you are allowed to either require a guarantor or an additional security deposit of up to a half month's rent. There's some notification requirements. You have to indicate this in writing. You have to indicate what would be required, i.e. a half month extra security. There's a 48-hour response period that they would have to accept or decline the opportunity. There are some limitations on screening guarantors. It's very interesting. It says, if the guarantor is a friend or family member, the landlord can't require the guarantor to have income greater than 3 times the rent amount. So I'm not sure about you guys, but so let's see. Do you see a lot of people who aren't friends or family members signing up to guarantee other people's rental agreements? Because I don't. I think they tend to be friends or family members. So I'm not entirely sure what the intent of that was, but I've heard some landlords now kind of saying that, if they're limited to 2 times or 2.5 times rather than whatever their old criteria may have been, they're simply just not going to allow, they're just going to reject the people. In other words, they're not going to say, okay, well, if you give me an extra half month security or get a guarantor, because some of the industry feeling I've heard is that if your criteria used to be 2.5 and now you're limited to 2.0, you kind of say either you meet that or you don't, and I'm not going to be comforted by a half month security. But that's up to you. You can certainly go either way. You just have to have a uniform policy. In other words, There can't be one applicant where you say, okay, well, we'll take you with an extra security deposit, but some other applicant, we're not going to take them with an extra security. Like, it has to be a uniform standard. And again, this is only if they don't meet the rent-to-income requirement. You can require an extra half-month security deposit. Don't think of it as if they don't meet some other requirement, you can increase the security. No, that's not the case. So for example, let's say that I know some landlords basically said they have policies where maybe you didn't meet the criminal, or you didn't meet, you had too recent of an eviction, and they would require an extra security deposit but still accept them. Well, you can't do that anymore. When we get to the security deposit part of this, you'll see that there are limitations on the amount of security you can charge, and the only exception that allows you to charge an additional half month's rent worth of extra security, it only ever applies solely as to the applicant not meeting this rent to income. So keep that in mind. Don't get confused and think that you can always accept anybody who didn't qualify by requiring an additional half-month security. Okay, so this part is one of the more concerning and confusing parts. And at this point, I am assuming and hoping that the majority of you have already made the decision as to which route you're going to go in terms of criteria, because you now have two choices. You can use Portland's low barrier criteria, which are sort of clear criteria that either the applicant makes it or they don't, or you can reject that and you can use your own criteria just as you always have, with the consequence being that each and every application must be subject to an individual assessment, which is something other than just saying you don't meet our criteria. So due to time constraints, I'm only going to kind of briefly go through these because, again, I'm assuming that you have already made these decisions or your property management company or ownership group has done so. Blue Moon does have low barrier criteria as a form. So if you have opted to use the low barrier criteria because of their comparative certainty and comparative ease of use, then that is available to you, and you would include that in your application packet because, again, that has to require that has to include your criteria. And your notice of unit availability, for example, might have a link to that low barrier criteria because, again, you have to have access to what the criteria are in your notice of dwelling unit availability. So it's really, they're called low barrier because they're fairly low threshold and will result in probably greater acceptance. At least that's the perception. So the criminal history, frankly, the non-convictions, diversions, dismissals, expungements, that's no different than it always has been. So that's no big deal. Crime no longer illegal in the state of Oregon. I think that was geared toward marijuana crimes, but it's not necessarily limited to that. So we'll see. We'll see what that means. Don't worry too much about it. But it would mean that, marijuana convictions. Juvenile, well, those are sealed, so that really doesn't matter. So the meat of it is really the misdemeanors more than 3 years old, felonies more than 7 years old. If you look at the Blue Moon form for the low barrier criteria, it also layers on state law because state law limits it to certain kinds of person or property crimes. And so the Blue Moon form really gives you a good overview as to what these limitations really are. But for example, if it's a misdemeanor that's 4 years, the date of sentencing was 4 years prior, if you've used the low barrier criteria, then that's not a bar. Likewise, felonies, if the date of sentencing was 7.5 years prior to the date of application, then you're not going to be able to exclude them for that felony because that's what this low barrier criteria says. Now, this is an important point. Even when you use low barrier criteria, you do have to consider supplemental evidence if you're going to deny solely based on a criminal conviction. Some of you may be familiar with that because of individualized assessments required under fair housing law in many circumstances. But so even if you're using low barrier, even if the applicant does not meet this minimal low barrier criminal standard, you still do need to consider their supplemental evidence and essentially conduct an individual assessment of their criminal conviction to determine whether maybe they should or should not be accepted. Individual assessments are complex, and I could present an entire seminar just on that, which I, of course, can't do today. So I would hope that anyone who is going to do an individual assessment instead of low barrier criteria, or who is needing to do an individual assessment, even if they're using low barrier because the applicant does not qualify under the criminal standard under the low barrier criteria, that you may need some legal assistance in figuring out how to properly consider supplemental evidence and perform a defensible individual assessment. All right, so moving on. Credit history under the low barrier criteria becomes less and less relevant. They only, as long as they have a 500 credit score, that's good enough, and then check out B here. So you can't reject them for insufficient credit history. So remember going back to that age-old question, if I don't have their social, then how can I run their credit and I have a 600 credit score requirement? Well, if they don't have a social, maybe they don't have a credit history. Well, if you are using the low barrier criteria, you can't reject them for having no credit history, unless you find out that they withheld something, et cetera, which is going to be fairly rare. So credit history essentially becomes minimally important if you use the low barrier criteria. If you cannot reject them for any negative credit amount that indicates a past due amount less than $1,000, and that excludes medical educational debt. If a credit report shows prior rental property damage of an amount less than $500, that's okay. You can't exclude them. And the bank, you'll see these bankruptcy things. I think the easiest thing to remember is essentially you cannot reject them for having a current or past bankruptcy. It no longer becomes relevant. And again, we're still discussing the low barrier. Now, rental history. You can't, if you're using the low barrier, you can't reject an applicant if there was an eviction. FED is an eviction case. If the tenant won it, well, guys, that's been the current law for many years now, so that shouldn't be an issue. Here's the change is subsection 2. You can't reject them if they lost an FED, but that judgment of eviction was entered 3 or more years before the date of application. So basically it just means anything that's older than 3 years does not count against them. And then B, this one gets kind of goofy. Even if it's a more recent eviction, meaning less than 3 years old, if that eviction judgment was based on a no-cause notice, or it was gotten by default judgment, meaning the tenant didn't show up to court, and the applicant can give you some kind of credible evidence that they had already moved out, and that's why they didn't show up to court, then, or if the relevant judgment was later set aside, which can happen under a new eviction expungement law that went into effect January 1. So if any of those things happen, even recent evictions can't be held against them. So keep that in mind. Information from references. My perception for many years has been that references are of minimal relevance. But you guys are on the ground, you may disagree, but my perception is that more and more landlords don't provide much reference information anyway out of concerns for liability or because they had a settlement and so on. And a lot of people have also pointed out that if one landlord wants to get rid of a tenant, they're probably not going to tell the prospective future landlord all the bad stuff about that tenant. Well, if you're using the low barrier, there is now a legal limit on what you can and can't consider regarding a reference. And it essentially means that the only thing that you can consider for a reference from a prior landlord is, or current landlord, is defaults in rent, 3 or more material violations within 1 year prior to the application if that landlord issued notices to that tenant, whether they owe an outstanding balance due to their current or past landlord, or lease violations that resulted in a termination with cause. That's it. So it's really only those 4 factors that you can rely on or should even inquire about in terms of a reference. Any other information, no matter how bad, would not be a legal basis to exclude them if you're using the low barrier criteria. All right, so individual assessment. If you are using your own criteria rather than the low barrier criteria, and any of your criteria are more strict than the low barrier criteria, you have to conduct an individual or individualized, you'll see both terms. You have to conduct an individual assessment of any basis on which you might deny that tenant, and you have to consider all of their supplemental evidence before you issue a denial. Here's some guidance here about what you have to consider in that individual assessment and supplemental evidence. And you can still deny them subject to these requirements. You can't discriminate. You have to comply with all the general rules, like income requirements, things like that, fair housing law. You have to provide them a written notice of denial within 2 weeks, and you have to include an explanation of the basis for denial, and you also have to include why their supplemental evidence did not adequately compensate for those factors that informed you to reject the application. The only thing I'm going to say here is that most people I know who are using the individual assessments are sort of employing someone to solely do these because it is not easy. They are complicated because an individual assessment means it's not a check the box. In other words, you can't just say, well, we applied our criteria and we rejected you because you didn't meet our criteria. Because that's literally no different than what the law is right now today. And so think about it, if it was that easy, then why would anybody adopt the low barrier criteria? The answer is because individual assessments take a lot of nuance, some legal savvy, and there's sort of risk and training issues in how to do these things right while not running afoul of fair housing, having consistency, and so forth. So do get some training if you do want to do individual assessments, and remember that you still have to do an individual assessment even when using low barrier in the criminal area. If you're denying a low barrier applicant solely on the basis of their criminal conviction that does not meet the low barrier criteria, you still need to consider any supplemental evidence they may have provided and conduct an individual assessment and explain that basis for denial. And there is, you're going to use the Portland Notice of Denial following individual assessment form that is a low barrier. that is a Blue Moon form. So you're going to use that if you're going to reject someone using your own criteria after you perform the individual assessment. And then you would also use that form to reject someone even if you're using the low barrier, but you're rejecting them after doing an individual assessment because of their criminal conviction. All right, there are some modification requirements here. Just be aware that if they request a modification, you now need to give them 2 successive 24-hour periods to request alternative modifications if you do not grant that. And this has already been the case. I mean, you can't deny their application because they requested a modification. And they're allowed to accept the unit without modification. So they could request a modification. You could deny it under applicable fair housing law, which is beyond the scope of this lecture. And they could say, okay, well, I want it anyway, and you would need to give it to them. Now, there is a requirement now that, and we talked about this, if you approve a financially responsible applicant, you can't then deny them just because a non-applicant tenant was also included. They get the opportunity. You always now have a 2-week limit to provide a written either acceptance, conditional acceptance, or denial. So you have to do that now within 2 weeks. I think most people are already doing that. An appeals process is required now. They now have an opportunity to appeal any denial for 30 days. They must be given an opportunity to correct, refute, or explain anything that they wanted. If after you consider whatever that appeal is and you decide to accept them, there's a 3-month pre-qualification period. However, this one is so vague, nobody knows what it means because it says that they're pre-qualified at the landlord's properties for 3 months following the date that you approve their application. Nobody knows if that means, because a landlord can simply mean a property management company, the way that the term is defined. And so does that mean that if they apply at one building with one ownership group and then appeal and you accept them, that somehow now they're just pre-qualified for a building across town or heck, in a totally different city that has 3 times the rent? Nobody really knows. That is, I think, one of the subjects of the pending lawsuit. So, but keep in mind that this 3-month pre-qualification period only applies if you accept their appeal and reverse the denial. And if that happens, then you're going to need to get some legal help on what this 3-month pre-qualification period may actually mean and how to handle that. It also means that you have to waive the screening fee for 3 months following an approved appeal. State law, by the way, says you can only charge a single applicant a screening fee once every 60 days. In Portland, in an appeal scenario, that ups it to 90 days. All right, so damages. If you fail to comply with any of the requirements we've been talking about, here's the liability. Up to $250 per violation plus actual damages. No one's exactly sure what those actual damages might be. Could be things like application fees at other properties and so on. The odd $250 violation every once in a while, probably not a huge deal. Systemic violations, or one applicant who, there were 6 or 7 violations, obviously that can add up and be concerning. It does allow them to sue for any violation of this statute. Okay, let's go through the security deposits. so that we do have time to answer the questions. I just want to make sure that we hit all the major points so that we don't leave any glaring omissions. So the number one question that I think a lot of people have about the security deposit stuff is, when does this apply? So if you have a rental agreement that is a brand new rental agreement, the first time you've ever had a landlord-tenant relationship with this person, starting March 1, 2020, every single thing that we talk about today in terms of security deposits is going to apply. Now, any tenancy that exists right now, meaning any rental agreement entered into prior to March 1, so even if you have a tenant that signs the rental agreement on Saturday, February 29th, then only certain requirements, the ones that are highlighted here, are going to apply. Because there are certain things that you just can't go back in time and do. So as we go through this, if you see the yellow highlight, that means that it does apply to existing tenancies right now. But every single thing, including highlighted and non-highlighted items, applies to brand new tenancies as of March 1 and beyond. Number one, now there's a limit on the security deposit amount. If you do not require a last month's rent deposit, then it is a month's rent. That's it, 1 month rent. The only exception being that, remember, if the financially responsible applicant does not meet that rent to income ratio that we discussed not long ago, you could say, okay, I will conditionally accept you if you pay an additional half month's rent. If you do that, you do have to allow them to pay that additional half month's rent in installments over a 3-month period. And all of that is in the Blue Moon Portland security deposit addendum form. So it will allow a payment plan and so forth. So again, if you have no last month's rent deposit, you can require a max of 1 month's rent as a security deposit. One of the questions I commonly get is, well, what about a pet deposit? The law really doesn't distinguish. So the grand total of all deposits, pet deposit or not, can only be 1 month's rent if you do not require a last month's rent deposit. Again, with the sole exception of that additional half month, if you're conditionally accepting someone who does not meet the rent to income ratio. Now, if you do require a last month's rent deposit, then you can only have a half month's rent. Same exception applies. You could require an additional half month if you're conditionally accepting a financially responsible applicant. So now, I mean, there's a cap, and so it just never, the absolute max security deposit that is allowed in Portland is a month and a half. And that's only in the scenario where you do not require a last month's rent deposit and you are conditionally accepting someone who doesn't quite meet the rent-to-income ratio. So 1.5, but the vast majority are going to be a single month's rent or a half month's rent if you're requiring a last month's rent deposit. And so I hope you understand the distinction between the two. A last month's rent deposit is legally distinct, and it is something that is literally a deposit that only applies to their last month's payment when either you or they terminate the tenancy, and it can't be used for anything else. Whereas a security deposit is a much broader a broader term, and it's not applied really until the tenancy is over. And going back, so this security deposit amount, just to be clear, this applies to everybody. period. You can't opt out of it. You can't have different criteria. This is a limit for everybody, is either a half month's rent or 1 month's rent, depending on whether you do or do not require a last month's rent deposit. This keeping security deposit in a separate account. Notice how this is not highlighted in yellow. So that means that existing tenancies that you have as of right now, this doesn't apply. This doesn't apply. This applies to initial rental agreements entered into on March 1st or thereafter. You have to keep it in a separate account. Can't be segregated into your personal operating account. You must achieve this within 2 weeks of receiving it. So let's say you sign a new rental agreement on March 2. That security deposit needs to be deposited into that separate account within 2 weeks of that date. The rental agreement must reflect information about the bank. And again, there is a blank for that in the Blue Moon Portland Security Deposit Addendum form. The has to disclose whether you are putting it in an interest-bearing account or not. Quite frankly, you can, if you put it in an interest-bearing account, it creates more accounting obligations for you and essentially gives the interest to the tenant. If you do not put it in an interest-bearing account, then you do not have any of those concerns. All right, so there are some new rental agreement provisions required now that are relative to security deposits. The rental agreement, as I just said, has to have the name and address of the bank, disclose whether it's in an interest-bearing account. So the security deposit addendum will cover that. It will also require an additional security deposit installment plan. Again, that is if you are doing a conditional acceptance and requiring that extra half month's rent, you have to allow them to pay it over a 3-month period, and this addendum allows you to insert that in so that there's specific dates and amounts as to when that additional half month will be paid. So the big one is this fixture, appliance, equipment, personal property addendum. It's a Blue Moon form of that title, and you're definitely going to want that. You will see that it's organized by categories. One of the more confusing aspects is that the ordinance and the administrative regulations don't really provide very clear definitions of fixtures, appliances, equipment, or personal property addendum, and yet you have to apply different depreciation to each of those categories. What is all of this for? Well, basically, the law in Portland is now that if you want to charge a tenant for repair or replacement of a particular non-structural item, you can only do so if that has been itemized in the rental agreement. And that rental agreement itemization indicates a whole bunch of information like depreciated value, purchase price, purchase date, or your estimate thereof if you're not sure. So basically, you have to complete all of this in order to potentially be able to withhold money from their security deposit later. So you're front-loading a whole lot of work. The Blue Moon has the depreciation schedule for you, and I'm not going to spend a ton of time on it, but this is what it looks like. This is, again, an official PHB form, and it takes you through the different types of properties, and it essentially says, so appliances or equipment depreciate over 15 years or a certain percentage per year. Then they have fixtures that are carpets and window dressings versus fixtures that are not, which is completely mystifying because in every area of the law, carpets and window dressings would never be considered fixtures, but in Portland, apparently they are. And then personal property, which is a catch-all. When you look at the Blue Moon form, the fixture, appliance, equipment, personal property addendum, it's organized by category. So first, I believe fixtures that are carpets and window dressings, fixtures not including carpets, appliances and equipment, and then personal property. And it allows you to essentially kind of go room by room within those categories, and it includes all the blanks and so forth. And so you'll be using this form in order to properly complete the Blue Moon form. So this is the depreciation schedule. I think it's going to be more challenging for a while, but then you'll get used to it. You'll have a baseline. You do have to do some math and double check some math. And the one thing I will say is that because the definitions are not very good or very clear, we're erring on the side of caution. So like personal property, you can see that there's no definition. It just says, if it doesn't fall within any of the former things, then it's personal property. We, like the attorneys at my firm, haven't come up with any clear example of personal property yet. And what we recommend is that if you're not sure where something falls, then pick a category that results in the highest depreciation rate. And that's because that actually inures to the tenant's benefit. The higher the depreciation rate, the less they can be charged for messing it up. And that might sound odd until you think about it, but let's say something's worth $1,000 and it is a fixture or it's a window dressing. Well, that means that if it's worth $1,000 and it depreciates 10% each year, then that, if they ruin it, they're charged less because it already has a lower depreciated value. So if you're in doubt and you're not sure whether something is personal property or, say, a fixture or equipment, err on the side of a higher depreciation rate, because the tenant can't really complain like, wait a minute, you should have charged me more money for that. And I know there are questions about what if you don't know the purchase date and all of that. There is a provision that allows you to, if you don't know that, you can approximate it and approximate the depreciated value using the schedule by using the same item or a comparable item. So it does require some research. It also does allow that if you think that there's a calculation that, you have something that really, the Portland depreciation schedule just doesn't apply, there's a space that allows you to justify that and deviate from it. And my suggestion, again, is that if you're going to do that, you get some legal advice at the outset. If you're going to put in your rental agreement something different from what the Portland depreciation schedule would yield. But it does allow you to do that. And there may be certain items, let's say that it's, because remember, this applies equally to everyone. So there might be some house that someone's renting that has an old antique mahogany door. That might justify a deviation from the depreciation schedule because it has a much higher value and et cetera, may not depreciate at the same rate. And as long as you put that in your rental agreement and provide some explanation and justification, presumably the ordinance does allow you to deviate from that depreciation schedule. But generally speaking, you should use the Portland depreciation schedule, deviate from it only very rarely and with legal advice, because if you use the depreciation schedule, then you are complying with the law. If you deviate from it, then there's some argument about whether you appropriately deviated from it or not. All right, so the next thing is the condition report. Now, this one, you can continue to use the inventory and condition form, which is an existing NAA form. And the only addition now is that there's a Portland addendum to the inventory and condition form. So most of it will be familiar to you. It's kind of, other people call it the move-in, move-out form. And you have to now affirmatively provide the tenant with this form. Again, the inventory and condition form, as well as the Portland addendum to the inventory and condition form, by the commencement date, which is just the date they're entitled to possession of the premises. So you need to give them the form. They then have 7 days to submit that report to you. And it's kind of, you should be familiar with the process where they now have the opportunity to note damages and conditions and so forth, so that it's supposed to create a record of what they can and can't be charged for, you know, pre-existing damage and so forth. I've had questions of, well, can you just do a walkthrough with them, like right when you give them the keys? You can certainly offer to do that and word it in a way that maximizes the chance that they're interested in, but can you insist that they do it and turn it in right there with you? No, because they have 7 days by law to do it. So you can certainly offer, but you cannot do anything that would require them to do anything other than turn it in to you within 7 days. Now, this is problematic. Basically, it says that whatever the tenant says goes. It says that if the tenant puts something in the condition report that they return to you and the landlord disagrees with it, well, you can obtain joint third-party validation, which is some mysterious third party. Nobody knows who these people are because they can't be a friend or family of either side, but some neutral party is supposed to come in and, you know, resolve the dispute and say, like, well, tenant says that this refrigerator is in poor condition and has scratches, and landlord says it's brand new out of the box in pristine condition. You can theoretically bring in this neutral third party who says, hey, I agree with landlord, this is brand new out of the box and it's not damaged at all. But unfortunately, the ordinance is very unclear as to, I mean, it doesn't say anything other than you can obtain it. It doesn't say what the process is or how you go about it or whether, you know, you have to listen to the third party. All it says is if third party validation is unsuccessful, then the tenant's condition report shall establish. So I think that's one of the areas that's going to be challenged legally because it seems to just say that whatever the tenant says goes is the bottom line, regardless of how many photos or proof you may have of what the condition actually is. So all I can tell you there is continue to document. I mean, you should be documenting the condition yourself with photographs before the tenant moves in anyway. And it's important to do that, and we'll see how this area develops. But the main thing is you do need to provide that, give the tenant the opportunity to return it within 7 days. What happens if they don't? Well, if they don't return it in that 7 days, then within 17 days of the commencement date, then you complete it, and you have to provide the condition report and digital photograph to the tenant within 17 days of the commencement date. So basically, on the day of move-in where they're given keys, you have to give them this condition report and the addendum. And then 7 days later, if they haven't turned it in, your clock is now ticking and you've got another 10 days where you provide them with a condition report and digital photograph. So yeah, it provides an enhanced obligation on you to provide them with photographs if they don't return the condition report. They don't have to provide you with photographs, but you have to do it if they haven't done so. If you intend to withhold any money from the security deposit to recover repairs or replacement of something that happens during the tenancy, you now have to update the condition report within 10 business days of completing that repair or replacement. But pay attention if you intend to withhold any money from the security deposit. If it's something that you know you're not going to charge the tenant for, I mean, there are any number of repairs and replacements that occur that are the tenant's not at fault. And so there's never an intention to charge them for that. So if you know that that's the case, you don't actually have to do an updated condition report. You can, if you think it's easier to always do one, but just letting you know that this is only required if you may potentially charge them for whatever that repair or replacement during the tenancy is. So, you know, let's say they sledgehammer the wall and you figure you're going to charge them for that, and you bring in a drywaller to repair it. Within 10 days of that, you have to provide an updated condition report that has to include the date of the work, the damage that was being repaired, updated depreciated value. If it applies, it wouldn't apply to a wall because a wall is structural and doesn't have a depreciated value, but let's say it was, you know, a toilet. And then any funds that you have already applied for repair replacement, which frankly I would assume is not a common practice nor one that I would recommend. In other words, don't use security deposit funds during the tenancy. Now, so let's say they do some kind of damage during the tenancy, you complete a repair, but forget to provide them with this updated condition report within 10 business days. What does that mean? Well, that means that when the tenancy ends, you're not able to withhold any money from their security deposit for that repair or replacement because you didn't update the condition report. That's what it means. Okay. And again, this one only applies to new tenancies as of March 1 because it's not highlighted. But now we get on to some more highlighted. What can you withhold? This applies to everybody. So this applies to your tenants right now and brand new tenants that you get 3 months from now. This applies to everyone. Well, you can only charge for actual costs. So you used to not have to do the repair in order to be able to charge for it. Under state law, that's the law. But under Portland law, it's an actual cost. The second one, well, you could never charge for routine maintenance, ordinary wear and tear, things that the tenant didn't cause, or pre-existing damage. So that's no change. The warranty, I think that's self-explanatory. Two fairly important things to process. So painting. You can't charge for painting unless it's specific tenant-caused damage beyond ordinary wear and tear, or to repaint when they painted without permission. So if it's just kind of touch-ups required due to ordinary wear and tear, you can't charge them for that. But if, you know, they spray painted or their kids scribbled all over the walls, things, you know, or there's a bunch of, maybe it's a non-smoking unit and there's nicotine coating the unit, that is specific tenant-caused damage. But you do have to be very careful that you're not charging them for painting that's just required due to ordinary wear and tear. I mean, frankly, you know, let's say someone has lived there for 5, 7 years, and they move out, you're probably going to need to repaint, but that may all be ordinary wear and tear, because the reality is that that's ordinary wear and tear is ordinary wear and tear. Nothing stays pristine forever. The concept behind ordinary wear and tear is that even good tenants living their lives in an orderly manner, over time, there's going to be wear and tear on things. So keep that in mind in terms of painting. And then here's the really hairy one for landlords, is the flooring, and the carpet. So as you all know, under state law, for many years now, so long as your rental agreement says that you're going to charge for carpet cleaning, regardless of whether they have it professionally cleaned, you've been allowed to then charge them for professional carpet cleaning as long as you have that disclosure. Well, Portland is purporting to change that rule for Portland landlords. And it says that, and this goes for both cleaning and repair of any kind of flooring or carpet, that you can only charge if additional cleaning or replacement is necessitated by use in excess of ordinary wear and tear. And this is very difficult, you can only charge for the cost of cleaning or replacing the discrete impacted area. So in other words, not the entire carpet. Presumably if there's an ink stain, you're supposed to just patch that area and charge them just for that patch rather than a full carpet replace. Let's talk about what this means for cleaning. So the difference again used to be that if you said you were going to charge them $150 carpet cleaning charge upon move out, regardless of whether they had it professionally cleaned, you used to be able to do that. Now, unless you can prove that that cleaning is necessary because they used the carpet beyond ordinary wear and tear, you are not going to be able to charge them for that carpet cleaning. Excuse me. And again, you can only charge them for the cost of cleaning and replacing the discrete impacted area. And so this is going to be very case by case as to what this means. I'm sort of wondering if landlords are going to start renting places with a patchwork of carpet since they, can't have a tenant pay for an entire carpet replacement. Are they just going to have all these weird unmatching patches rather than have a nice uniform carpet as has been the practice? And remember, this is also where depreciated value is going to come in when you're ultimately charging them based on the depreciation schedule that you have memorialized in the rental agreement. You still have to do an itemized final accounting. State law says 31 days. Frankly, you got me. The language in the ordinance is very bungled, and it seems to maybe say that it's due within 30 days. I frankly can't tell, so I always figure it's best to be safe. So now endeavor to get your final accountings out in 30 days. Still have to comply with state law, which means via first-class mail. Now you do have to include photos of visual damage for new tenancies. You're going to have to justify your labor costs with documentation. And you do have to have a security deposit notice of rights. That is a Blue Moon form that is available to you with each and every final accounting that you now send out. And so if you're not the one who's doing it and accounting is doing it, everyone needs to make sure that whoever is actually doing final accountings in terms of sending them out to tenants has to include the security deposit notice of rights, because failure to do that right there is a violation that results in massive liability. And again, looking at all the yellow items are in effect even for existing tenancies. So let's say you have a current tenant right now who moves out March 10th. When you do their final accounting, you're going to apply these standards that are highlighted in yellow. And then you're also going to include the security deposit notice of rights with that final accounting. And then again, because every single thing we talk about today, all of this, regardless of whether it's yellow or not, all of this applies to brand new tenancies that begin on or after March 1. Okay, final inspection. This is one of the worst provisions in the ordinance. No one's entirely sure what it means, so I've just reproduced the language so you can see what I mean. Within 1 week following the termination date, the landlord shall conduct a walkthrough of the dwelling unit at the tenant's option with the tenant or tenant's representative to document any damage beyond ordinary wear and tear not noted on the condition report. The tenant and or the tenant's representative may choose to be present for the final inspection. Landlord must give notice of the date and time of the final inspection at least 24 hours in advance. Well, there is a lot of ambiguity here. Does this mean that the tenant has to request it? I don't think so. No one actually knows for sure what 7 days of termination, 1 week following the termination date. Termination date is not well defined. There are a number of arguments as to what it means. It says termination of the rental agreement. Well, that's not helpful. Most people assume that since it's a final inspection, they're talking about the date that you have possession back. However, that's not entirely clear because when you give a termination notice, let's say you give a 72-hour notice, what does it say? It says the rental agreement will be terminated if they do not pay by such and such date. So if you give a 72 that terminates the rental agreement as of March 20th, does that mean, and they don't pay and they don't move out, okay, so their rental agreement has been terminated, does that mean you now have a week to conduct a final walkthrough even though they haven't moved out and maybe you're in the middle of the FED process? You can see how absurd that seems, and yet the language allows that argument. So you're going to have to make some decisions about how you want to play it. At the very least, assuming none of those things happened and there's no ambiguity, it's just that, you know, a tenant moved out, you should give a notice to the tenant of when you're going to conduct a walkthrough, a date and time. The ordinance doesn't specify how you have to serve that notice. It doesn't say anything about having to coordinate with the tenant or give them more than one option or reschedule if they don't like the time. It doesn't say you have to do any of that. It seems to just sort of say you have to give them a heads up that, hey, I'm going to do this inspection on such and such day and time, and you can come if you want, or you or your representative. And I know there are issues with tenants who may be perceived as violent and so on, and you're going to have to get legal counsel if you think that something like that is going to apply, because guess what? The ordinance somehow doesn't imagine that those situations might ever exist. It seems to think everything is just peachy keen at the end of any tenancy and that everyone's going to have this final inspection and sing Kumbaya together. So if that's not the case and you're feeling that there may be safety or other issues associated with conducting this, then those are some of the issues that you're going to have to work through and do some risk assessment with tailored advice specific to your situation. Okay, final thing here so that we have a little bit of extra time is rent payment history. And this applies again to everybody. The safest way, there's ambiguity about this as well, there's a Blue Moon form. You have to provide it within 5 business days if you serve a termination notice on the tenant. So most people are going to serve it along with that termination notice. You have to provide it within 5 days of a tenant requesting it. And although I do not think it is actually law, because of the way the Portland Housing Bureau form is worded, many people are feeling like it's safest to also give it to the tenant if they give you a notice of intent to vacate. Again, the name of the game is trying to play the odds and minimize risk. And so if that's the case, you will want to serve them with any and all termination notices, although we think that maybe they're only required with certain termination notices, but because it's ambiguous, Many landlords are electing to serve the rent payment history form with each and every termination notice upon request and if you get a request from a tenant. And that is this form. And you just fill it in. And then you'll see here, fill it out just as the form says. The month and the year, did they pay, yes or no? Don't add extra info or you open yourself up to some argument that maybe you didn't comply because you didn't just put yes or no as it indicates. So to finish up the damages, so this one is pretty harsh. Any failure to comply with any requirement means you shall be liable for twice the amount of security deposit plus attorney fees and costs. So that's a lot. So in all of these ambiguous areas, like I said, while we think there's a pretty solid argument, for example, that the rent history form does not have to be provided with certain kinds of termination notices, we kind of figure that it's ambiguous and most people aren't willing to risk twice the amount of security deposit to make that argument. Hence, landlords are just going to start serving them with every single termination notice to be safe so that they don't run that risk, because this damage provision is quite harsh and provides for major liability for any infraction, no matter how minor it seems. Okay. I am going to open it up, I suppose. I know there are about 1 million questions here. And Aisha, you'll have to kind of tell me when, I'm sure many people have left already. You'll have to, I can stay for a while if people wish to stay.
Okay. I will first start with the questions in the Q&A box. And if it's a question, and if it's just a question that you can address on the webinar, just say so, and we'll move to the next one.
All right.
Okay. First question, does all this apply to Beaverton, Oregon?
No, it does not. At the outset, I said this applies only to properties that are within the geographical city limits of Portland and nowhere else.
Okay. We take online applications we take online applications, a very abbreviated application form. I'm wondering if the required forms can be an after apply item, or do we have to add a link in our online process to access the documents?
You have to comply with the application requirements. And so I think if you have an application that does not, if you have an abbreviated application that does not contain all of the required elements that I've described today, that could be problematic. And so I think the bottom line again is that the law says that your application must contain the following information.
Okay.
And so if yours doesn't, you're going to need to address that.
Next question, we require an application fee and do not consider an application complete until the fee is paid. Would the time the fee is paid be considered the received time and date?
The ordinance does not specifically address that, but if you are requiring a screening fee in order to process it, you're certainly not required to process it until you have that fee in hand.
Okay. If the application is materially incomplete, can I add, I think this is along the same lines. If the application is materially incomplete, can I date and timestamp it at the time we receive enough information to make it complete?
Yes, I mean, the ordinance requires you to date and time stamp when you receive a complete application. So if it's not a complete application, which, as you noted, means that it's missing something material, then you have not received a completed application yet. And only when you do would you then date and timestamp it as to when you actually received it. You're basically not date and time stamping it until you have what you need to process it.
Okay. Next question is, if you are not tracking whether a unit is accessible, is it required to determine if it meets the standard, or can it remain unclassified?
You are required to disclose whether it is an accessible dwelling unit. So you do have to determine whether the unit is an accessible dwelling unit.
All right. Next question is, does the ordinance list any penalties or checks and balances for this type of scenario? A person applies and is the first in. That person lists themselves as the financially responsible applicant and lists other tenants, then gets the unit, but only the non-financially responsible applicants move in, and the screened financially responsible applicant does not move in, but pays for it.
Well, I'm assuming that the financially responsible applicant has signed the rental agreement, or else I'm not sure how you would have allowed anybody to move in. And so in that scenario, if the financially responsible applicant has signed the rental agreement, you know, along with the non-financially responsible applicants, they are all parties to the rental agreement, which gives them the right to possession. And if the question is, if you find out that the financially responsible applicant isn't actually living there, can you somehow kick the other people out? My answer is generally going to be no, as long as rent is being paid. I mean, if rent's not being paid, then you have your remedy. But again, theoretically, every single tenant you have has the right to sign your rental agreement, but never actually live there. And so I hope that addresses your question. And if it's more nuanced than that, it might be a scenario where you need some individual legal advice.
Next question is, will saying that we use Portland's low barrier criteria and providing a link to their rental services office be sufficient to meet the requirement for screening fees?
I am not sure that okay, so I understand the question to be, can we just link to the Portland Housing Bureau website? Unless they have low barrier screening criteria in a clear linked place, which I'm not sure that they do, I would have some concerns with that. Again, Blue Moon does have actual low barrier criteria that clearly articulate what those criteria are. And I believe you'd be in a much better position to link to that rather than a Portland Housing Bureau website. You do have to, in order to charge the screening fee, you do have to, of course, provide the criteria, the actual criteria. The low barrier, if you're just linking to the Portland Housing Bureau, I assume you're probably just linking to the administrative rule, which has a whole bunch of other stuff and actually just basically says your criteria can't be any more stringent than this, but it doesn't actually list specific criteria. So I would encourage you to utilize the actual criteria form provided by Blue Moon.
If the financially responsible tenant moves out, can we also require the non-financially responsible tenant to move out as well?
No. Don't think of that as any different. I mean, basically, the general rule is once they're in, they're in. So there's really nothing, there's nothing that would provide any ability to terminate the tenancies of non-financially responsible applicants. If the financially responsible tenant moves out and yet rent is being paid, then so be it, and you don't have any remedy. Now, if the financially responsible tenant moves out and rent stops being paid, well then yes, you'll be able to terminate based on non-payment of rent. But if you are asking if there's some way to terminate the tenancy solely on the basis that the financially responsible tenant moved out, the answer to that is no.
A question related to screening. If an applicant has a social security number but does not want to provide it, are they able to do so?
Yes, you cannot require a social security number. You can ask, you can absolutely ask, but if they do not have one or refuse to provide it, that in and of itself cannot be a basis for you to reject an application.
Okay. Should the payment history form only include rent or any charges such as pet premiums, utilities, carports, etc.?
The form appears to just say rent, and so that is the safest thing, is to just determine whether they paid base rent in a given month and put yes or no, and not worry about other items, not for purposes of that form. Just fill it out as it exists. And the column says rent, and it doesn't have an other charges column, so just include rent.
Okay. If we are requiring an additional half-month rent and they are on a payment plan and default, what happens?
If you use the Blue Moon security deposit addendum that provides for a payment plan, that becomes a part of the rental agreement. So it would be like non-payment of a late fee or something like that, meaning that it could be a potential cause basis for termination of the tenancy. It would be a curable for cause is the way we believe that would work.
Question regarding deposits. With the 1 or 1.5 times the rent as deposit limitation, can we still charge a separate $250 pet deposit on top of the other deposits? PHB's response was not helpful.
Okay, yes. So the answer to that question is no. The total amount of any and all deposits that you charge, however categorized, however, the total amount of any security deposit you charge cannot exceed the cap. So if what applies to you is 1 month's rent, then that is the maximum, and you could not do an additional pet deposit, because under the law, a pet deposit is not some distinct type of thing. A pet deposit is really just a security deposit called by a more specific name. So the answer is no. That the maximum that applies, that's the absolute max that applies to every single deposit you take, other than a last month's rent deposit, because that's not a security deposit.
Great. A question regarding landlord choice screening. An applicant has bad credit. We do individualized assessments. Can we then ask for the additional half month's rent and or a cosigner for that reason? Otherwise, I believe we'll have a lot of denials.
Now, that's a good question, and the answer to that is no. The only allowance to charge that additional half month's rent security deposit is only if the financially responsible applicants do not meet the minimum rent to income ratio. That's it. So if they don't meet other financial requirements, you cannot require that additional half month's rent.
Okay. Next question. My understanding of the Fair Ordinance was in part to the intent of the new Fair Ordinance was to prevent us from charging a screening fee for non-applicant tenants. My understanding was this was related to ORS 90.302 and the allowable fees a landlord can charge. My question relates to the ORS definition of a tenant. Specifically, a tenant is defined as a person, including a roomer, entitled under a rental agreement to occupy a dwelling unit to the exclusion of others. Given that the Fair Ordinance refers to a non-financially responsible applicant as a non-applicant tenant, could we make the argument that because the non-applicant tenant is not entitled under a rental agreement and thus not a tenant under Oregon law, that ORS 90.302 does not apply in this situation as it specifies allowable fees only for tenants as defined in that statute?
Yes, you could make that argument. Will that argument succeed? I don't know. This is a very nuanced argument, and it is one of many areas that is being used to question the viability of certain provisions of the Fair Ordinance. Because it is simply not, I mean, there are some attorneys who think that there is an argument that the Fair Ordinance would not allow you to charge a screening fee at all to non-applicant tenants. That is simply an argument. There are arguments to the contrary. So I know it's a highly unsatisfying answer, but that is one of the most complex, gnarliest areas of this statute that is going to be litigated. And I think the main question is whether you want to be one of the test cases for that or not. So to literally answer your question, yes, there is such an argument, but I cannot sort of guarantee you what the result of that is going to be, because it's a complicated argument that will probably take briefings of, dozens of pages and lots of case law research and so forth. But it's a very perceptive question, and you've kind of gotten to the heart of one of the most difficult areas of the ordinance.
Should all applicants still be listed in the lessees section if they are over 18, or should the non-financially responsible applicants be moved to the occupant section of the NAA lease?
Because that relates to the last question and touches upon a very ambiguous area of the ordinance, and I know that you're going to be gritting your teeth when I say this, but I do think that if you have that particular specific question, because there are risks associated with either choice you make, you are going to want to consult your own counsel for a much more tailored risk analysis than I'm able to give you in this informational session.
Someone's asking for a bit of clarification. The last month's rent is not a security deposit. Did I mishear that? If there is money owed, can the last month's rent be used to reconcile?
Okay, so the law for many years has distinguished between security deposits and last month's rent deposits, both of which are traditionally paid at the outset of the tenancy. The difference being that a last month's rent deposit must be specifically designated as a last month's rent deposit in the rental agreement and consequently can only be applied to pay rent in the last month of the tenancy. The way it's supposed to work is if you have taken a last month's rent deposit, your rental agreement says so and specifically calls it a last month's rent deposit, and then let's say the tenant gives you a 30-day notice that, you know what, they're not going to renew their lease, they're going to move out. When they give you that notice, that's when, according to law, you apply their last month's rent deposit to that last month during which they say they're going to live in the premises. And that is the only thing you can ever apply a last month's rent deposit to. Let's contrast that with a security deposit. A security deposit is designated as a security deposit in the rental agreement, and while it can be used to pay unpaid rents that remain unpaid at the time the tenant moves out, it cannot be used in the way that I have just described. So let's say you only have a security deposit and the tenant gives you a 30-day notice that says they're going to vacate March 31st. Do you then use their security deposit on March 1st to pay March rent? No, you do not, because that's how you use a last month's rent deposit. Instead, if they failed to pay March rent, you could serve a 72, and whenever they eventually vacated, you could then use the security deposit to pay March rent if it never did get paid. But I hope you understand those two distinctions. They are two legally distinct things, and so if you charge a last month's rent deposit, that's what limits you to a 1/2 month's rent security deposit. The other distinction being that security deposits can, of course, also be used to pay for unpaid late fees, unpaid utilities, damage to the premises beyond ordinary wear and tear. Whereas a last month's rent deposit couldn't be used for any of those things because you're only using it, as I described a little bit earlier, to pay that last month's rent during the tenancy before they vacate.
Great. Next question. Can you please confirm that the rent to income is the only criteria point that we can require an additional deposit or guarantor for?
Yes, I confirm that. It is not it's very, very narrowly worded and refers only to the income ratios. And that means that if they don't meet some other financial criteria of yours, I believe there was a question earlier regarding credit score, for example, you cannot require the additional 1/2 month's deposit. You cannot conditionally accept them. So it's very narrow, perhaps narrower than they intended or thought about, but that's what the language says. And so you are limited to doing a conditional acceptance only if it's just the income ratio requirement that the financially responsible applicant has failed to meet.
And a question along the same lines. Are you allowed to require a guarantor if the applicant has not failed the low barrier screening?
No. If they qualify under low barrier screening, I do not see a basis in the ordinance or administrative rule that would allow you to require a guarantor.
A question about the notice of availability. Can that just appear in the first posting of the ad? For example, it will usually be on the website when we first find the unit vacant, or does it have to appear in every subsequent ad, even after the 72 hours have passed after that initial posting?
The ordinance isn't entirely clear on that, but it seems to say that they have to publish a notice of dwelling unit availability. I mean, it says, I'll read the statute. It says, if a landlord advertises a dwelling unit's availability, the landlord must publish notices for rental of the available dwelling unit at least 72 hours prior. And then it says the notice must specify the following. So I said earlier that in ambiguous areas, we of course recommend caution. And so I think the safest bet is to include it in all advertisements. And if you're, including an advertisement that essentially has a link for all of the relevant info, hopefully that won't be too onerous. But bottom line, ordinance is pretty hazy on that issue. And so I would err on the side of caution and assume that it's not just the first notice, because it doesn't say it's just the first notice.
There are a couple of questions about how do you go about checking criminal history when doing the background check if you're unable to collect the applicant's social security number. And related along those same lines, when the non-financially parties stay after the financially responsible applicant moves out, if you're not collecting social security numbers, again, how do you go about finding those individuals when you don't know where they work, their income, nothing except their criminal background?
Okay, so the criminal background part of it, first of all, I think you should talk with your screening company about that. I'm not an expert on, the logistics of actual screening, but I frankly doubt that a social security number is required to conduct criminal screening, and here's why. What criminal screening is doing, what those screening companies are doing, are using programs that dip into state court databases to find data, and state court databases do not contain social security numbers for identity theft reasons. So for example, if I, have a criminal conviction and you look at the entire court record of that, it's not going to have my social security number in there because the court isn't allowed to even publish social security numbers for obvious reasons. So criminal records are accessed, to my understanding, through name and date of birth. So I actually don't think, again, verify this with your screening company, but I do not think that a lack of a social will prohibit a solid criminal screening. And if I understood the second half of the question correctly, it was more about post-tenancy collection procedures. Is that right, Aisha?
That's correct.
Well,
for the non-financially responsible applicants.
Yeah, collection has always posed a problem post-tenancy because, you may or may not, maybe you had their employer information or so forth, but that may have changed in the, 6 years that they lived at their unit. So, I think the bottom line is that the ordinance, you have to comply with the ordinance, which says that you cannot financially screen non-applicant tenants, and they don't care what effect that has on your ability to collect later. So I assume it will pose additional challenges. And frankly, I'll throw it out there that another ambiguity is, I mean, some people are wondering whether the non-applicant tenants, in a literal sense, can be held financially liable, because that's not entirely clear. Some people read it to simply mean that for screening purposes, it just means you can't screen them for financial stuff. Other people are saying, no, it literally means that they're not financially responsible for anything that happens in the unit. And that is a question that will only be answered through litigation. So I don't have a good answer for you on collectability other than to acknowledge that it probably will pose an additional challenge.
Okay. And I'm going to ask this last question, and then I will wrap us up. We are going on our 2.5-hour mark.
Yep.
Last question. We have new residents who have already signed their lease, but the tenancy begins after the new law takes effect. Do we need to get them to re-sign a new lease?
No. So the security deposit stuff, it applies when the rental agreement is entered into on or after. So I think it doesn't really talk about when the tenancy begins, or when it's not based on the possession date, it's based on when a rental agreement was entered into. So I think that's your measuring date.
So again, Anna, thank you very much. That concludes our webinar for today. And I want to thank you all for participating, and I hope that you enjoy the rest of your day.
Yes, thank you for everyone's attention during this really in-depth discussion of a very difficult subject, and I hope the rest of your day is much more enjoyable than I know this was. Thank you so much. It's been my pleasure.
Thank you, Anna. Have a great day, everyone.